Rachita Vedam, Vachasi Somamadi. Speech is a powerful instrument. Through it is revealed law and order. The Rig Veda extols the power of speech as a vehicle of law and justice. Indeed, advocacy is the noble art of speech in service of truth and dharma. Good evening, Honorable Vice Chancellor Professor Dr. P.P. Saxena, Shri Peeyush Verma, learned senior advocate and President of the Himachal Pradesh High Court Bar Association, Professor Dr. Girjesh Shukla, Director, Clinical Legal Education Center, esteemed dignitaries, respected faculty, and dear students, I, Dr. Bharat Barwalia, convener Trial Advocacy Cell, welcome you to the orientation program of HPNLU Trial Advocacy Competition Criminal 2025, organized by the Trial Advocacy Cell, Clinical Legal Education Center. It is my privilege to introduce the initiative at the very core of today's orientation, the HPNLU Trial Advocacy Competition, organized by the Center. This is a pioneering intra-university program meticulously designed to simulate real criminal trial proceedings spanning from FIR filing to final arguments. It is structured to cultivate advocacy finesse, procedural acumen, and courtroom ethics, offering you, the participants, a pragmatic bridge between theory and courtroom reality. This competition is not merely an event, it is a transformative educational platform, a crucible for refining your legal articulation and courtroom presence. May it inspire you to think on the footing of the litigators and argue like advocates and embody the ethos of legal professionalism. At this moment, may I request our Honorable Vice Chancellor, Professor Dr. Preeti Saxena, to kindly felicitate our Chief Guest, Shri Peeyush Verma, Learned Senior Advocate and President, HP High Court Bar Association. Thank you, ma'am. The initiative we mark today is not merely a competition, but an academic experiment in learning by doing. The HPNLU Trial Advocacy Competition reflects the university's conviction that the true test of legal education lies in its application. By placing our students in a simulated courtrooms, it challenges them to transform knowledge into practice, theory into argument, and principle into performance. It is also significant that this competition has been designed to mirror the entire spectrum of a criminal trial, enabling participants to appreciate not only the role of advocates, but also that of the investigators, witnesses, and even the accused. In this way, the exercise instills empathy, procedural sensitivity, and a holistic understanding of justice delivery mechanism. At the heart of this initiative stands a director of Clinical Legal Education Center, and it is my honor to invite Professor Dr. Girjesh Shukla, director of the center, to deliver the welcome address.
Thank you, Dr. Bharat. Honorable Chief Guest, Shri Peeyush Verma ji, President, Himachal Pradesh High Court Bar Association, Honorable Madam Vice Chancellor, member of the HPNLU Clinical Legal Education Center, my fellow colleagues and dear students. It's my proud privilege to extend a very warm welcome to each one of you on this August occasion of inaugural ceremony of HPNLU Trial Advocacy Competition 2025. At the very outset, I take this opportunity to express my heartfelt gratitude towards Honorable Mr. Justice Gurmeet Singh Sandavalia, Chief Justice of Himachal High Court and Chancellor of HPNLU Shimla, for guiding us towards academic excellence. We are equally honored by having Honorable Justice C.V. Barawalia, Lok Ayukta Himachal Pradesh, as part of our advisory board, whose wisdom and judicial experience have always guided us. I extend a warm welcome to the chief guest, Shri Peeyush Verma ji, and probably in Himachal Bar is the one of the best person to inaugurate this rare training program, I would say, across any national law university. A person with more than 30 years of experience at bar, a person who won the bar presidency election by more than 200% votes, and a person coming from the such a nice legal fraternity. Sir, this is our proud privilege to have you here for the inaugural ceremony of this program. Thank you so much for coming. I extend a warm welcome to our Honorable Vice Chancellor, Madam, whose visionary leadership and emphasis on skill-based legal education have been the driving force behind conceiving and designing this competition. You will be surprised to know, dear sir, chief guest sir, that this is the only national law school where a center, a specialized center for clinical legal education has been constituted. Other than no 25 amongst 25 national schools, there is no clinical legal education center. So thank you, ma'am, for taking this initiative and guiding us towards a legal excellence. Distinguished faculty members, your presence today adds value and inspiration to this ceremony. The HPNLU Trial Advocacy Competition 2025 is a pioneering initiative of Clinical Legal Education Center, HPNLU. It has been conceptualized not merely as a competition, but as a learning cum training program. Shri Verma ji, this program will run not for 1, 2, or 3 days. It is 1 year continuous training program. It has already started in terms of inviting expression of interest on 11th of July, and it will conclude on 30th of April. And that will see a lot of activities from workshop, training program, and actual competition on already as per the schedule notified. And according to that schedule, the orientation cum inaugural is being conducted today. It has been conceptualized not merely a competition, but a learning cum training program, and it seeks to stimulate real trial court proceeding, thereby allowing our students to step into the shoes of investigating officer, prosecutor, defense counsels, and along with that, the other pressures of this university will understand the nuances of running and managing the court. They will perform the job of registry cum court masters, and along with that, our senior student will, along with the advocates, will perform the job of judges during this whole 1 year long training program. Through this exercise, the competition intends to cultivate and refine trial advocacy skill amongst students, provide them with practical training in criminal trial practice, promote healthy competitiveness and professional discipline, bridging the gap between theory and practice in the legal education. This year-long exercise, spreading from July 25 to April 26, has been meticulously structured into various stages, running from filing of FIR, conducting full-fledged investigation, taking cognizance, framing of charges, and followed by prosecution and defense evidence. So that's way a real-time court will be operating in this campus. And thanks to Honorable Vice Chancellor, Madam, that probably again I would say this is the only national school which have a dedicated trial advocacy, not only a center but also a room wherein the student can operate 24/7. This is a rare achievement in that way, and thank you, ma'am, for providing that support. HDFE 2025 rule book lays down detailed structure of the proceeding, designed to mirror the real court trial under the Bharatiya Nyaya Sanhita 2023, Bharatiya Nagarik Suraksha Sanhita 2023, along with Bharatiya Sakshya Adhiniyam 2023. It will include the pre-trial processes. I will not go into the details of that. It will also include cognizance stage, framing of charges stage, prosecution evidence, defense evidence, final argument stage, miscellaneous proceeding also. This is the rare sort of combination, and I would like to emphasize on this point, Honorable Chief Guest and other dignitaries present here. During this trial court proceeding, sir, a parallel senior courts will also be sitting here, constitutional court. For example, if a person is arrested and want to go for bail, then the bail court, and if the bail is rejected by session court, then bail by high court will also be considered in the same hall. So a high court bench regularly will be sitting here for the purpose of disposing of those type of cases in all those artificial manner, and that will give a sort of a real sense training to the all these court proceedings. This whole program has been designed in a way that we all understand students will not learn all these things from books. So for that purpose, at every stage, there will be a separate workshop from the field expert. Say, for example, during investigation, we have scheduled 3 workshops, 2 from the police officers, and I'm so happy and glad to inform all of you that due to efforts of Dr. Bharat Borwalia, already 2 senior police officers have consented for the purpose of workshop, which is going to be scheduled on 8th and 18th of September this year, followed by a full-fledged workshop by a public prosecutor from Himachal Pradesh itself, who would be training the students how to go for conducting investigation in a fashion which can result into a better prosecution setup. Further, at the time of trial, the consent have already been received from the various prosecutors from Himachal Pradesh, Punjab and Haryana, Uttar Pradesh, as well as Delhi. We have listed almost 17 prosecutors who have been already consented to be part of this learning exercise. This program is articulated in a more competitive manner. So at the beginning, we have received total 83 registration, and each individual will be holding their own case. However, during the proceeding, there are a lot of elimination rounds. At least 4 elimination rounds are there. And finally, in the month of April, only 4 teams will be there who would be, I am dreaming, who would be presenting their final argument here in this court hall only, in this room only. And at that point of time, I seek your consent to be part of that proceeding here right now. Dear sir, this is in fact a whole idea conceived as not short of class learning, but a courtroom laboratory, where experimentation in terms of investigation, experimentation and experimentative learning in terms of investigation, framing of charges, taking court proceedings in terms of prosecution evidence, in terms of defense evidence and arguments, all these things will be done in a more practical manner. This vision would not have been possible, sir, without the inspiring leadership of our Honorable Vice Chancellor, Professor Dr. Preeti Saxena, whose commitment to clinical and skill-oriented pedagogy has shaped the framework of HTAC. We are happy to share with the August gathering that we have already received a good number of not only registration for the purpose of the program, but also to run the court in terms of registry and court masters, and also the field experts who have been kind enough to consent for this program. The list includes serving and retired judges from the various trial courts, including Himachal Pradesh, public prosecutor from Himachal Pradesh, Delhi, Uttar Pradesh, along with experienced investigating officers and advocates who would join us as a resource person and would play the role of judges during the trial. Dear students, participating in this year-long program, you are not just competitor, but learner in truest sense. This competition will demand from you not only a sharp legal reasoning and drafting skill, but at the same time, the requisite acumen of an investigating officer, along with a courtroom etiquette, presence of mind, clarity in administrative as well as advocacy skill, and above all, an integrity. It will test your ability to think like a prosecutor, argue like a defense counsel, examine witnesses with precision, and persuade judges with conviction. In doing so, it will prepare you for the noble responsibility of ensuring justice in the society. Remember, the essence of advocacy lies not in arguing the law, but also in upholding fairness and justice. With the blessing of our Honorable Vice Chancellor, I'm sure this competition would be our modest step towards nurturing the essence of advocacy amongst the future lawyers serving the cause of justice. On behalf of HPNLU Shimla, I extend my best wishes to all the participants, and I once again welcome you, sir, here and on this inaugural ceremony. Thank you.
Thank you, sir, for the warm and insightful words with which you have set a reflective and inspiring tone for today's event. It gives me immense pleasure to introduce our chief guest, Shri Peeyush Verma, learned senior advocate and president of the Himachal Pradesh High Court Bar Association, elected to this prestigious position in September 2024. With nearly 27 years of legal practice in Shimla, Sir has earned a reputation for legal acumen, ethical commitment, and leadership, qualities essential not just in practice, but in mentoring the next generation of legal professionals. As a respected advocate of the Himachal Pradesh High Court, Sir brings a wealth of experience, legal acumen, and leadership. I now have the privilege of inviting our chief guest, Shri Peeyush Verma, learned senior advocate, to address this august gathering. Sir, the podium is yours.
Honorable Vice Chancellor, respected Professor Dr. Girish Ji, Chairman of this Clinical Legal Education Center, respected teachers, and many budding jurists, lawyers, judges, prosecutors, and legal luminaries of the coming days. And last but not the least, my colleagues from the HP High Court Bar Association. It gives me immense pleasure to be in one of the most prestigious universities of this state, the Himachal Pradesh National Law University, for which no amount of praise would be sufficient. I begin by thanking all of you in taking me 30 years back into my life, when in the late 80s and the early 90s, I was also a student like you, young, energetic, vivacious, and naughty. I remember my university days just because you've given me an opportunity to come here and address you all. I begin by congratulating the Honorable Vice Chancellor and the respected teachers who have taken this first initiative of a kind, which does not exist anywhere in the country, as was told just a few minutes back, which would prepare the students of this university, majority of whom belong to the state of Himachal Pradesh, to prepare themselves for trial court advocacy, to be judges, to be prosecutors, to be defense counsels, to be jurists, to be teachers who would make this country proud in times to come. I congratulate you for this. Before I say anything or address anything on the aspect of trial court advocacy, I would want all of you to remember two things. One, there is no shortcut to success. Two, if you work hard, then you are bound to succeed. So always keep this in mind, that there is no shortcut to success. And if you choose to work hard, you are bound to be successful. Once you complete your law, the whole world would be open for you. You would have many avenues. You can choose to be teachers. You can choose to be judges. You can choose to be prosecutors. You can choose to be lawyers. And if you choose to be lawyers, then you can further choose to be lawyers in a particular field. And if you choose to be criminal lawyers, you can choose to be lawyers in the trial court or lawyers in the appellate court. Here, what I would say would be a bit different from what many others feel. Most of the people have this impression that those working in the High Court or before the Supreme Court are better lawyers. But I would say this, that a better lawyer is one who works hard, prepares his brief, and presents himself in a better manner. And if you are to compare trial court lawyers to appellate court lawyers, then in the words of Honorable Justice Wajif Dar, former Chief Justice of the Honorable High Court of Punjab and Haryana, he very aptly described a trial lawyer is an artist, whereas an appellate lawyer is a critic. And all of us know who's better, an artist or a critic. As an artist, you have to develop a story. You have to articulate things. You have to decide what to say, when to say, and how to say. And you further have to decide what not to say, how not to say it, and when not to say it. So, if you practice this art well, then success follows you. As far as the appellate court is concerned, or the appellate lawyer is concerned, he is merely to decide that he shouldn't have said this, he shouldn't have articulated this. What he has done here is wrong. What he had done there, he ought not to have done this. So, there is a big difference between a critic and an artist. And I think it would be an artist who would be respected more. Next, before becoming good trial court advocates on the criminal side, we are required to know a few basics. Those few basics are the different stages in the criminal prosecution system. If you know all those stages, which you ought to know as a trial court lawyer, as a criminal lawyer, then this knowledge would stand you in good stead. And every time you get stuck, go back to the basics. Every time you feel you do not know what to do, go back to the basics. And every time you read the basics again, there would be a different interpretation, a different help that those basic provisions would give you. To begin with, as the procedure starts, the criminal law starts with an offense. An offense is committed. The machinery of criminal law is set into motion by commission of an offense. Now, offenses are of two types. The more serious ones, cognizable, non-bailable. As lawyers, you're required to know what is a cognizable offense, what is a non-cognizable offense, what is a bailable offense, what is a non-bailable offense. A cognizable offense is one where the police officer can arrest without a warrant. Normally, the serious kinds of offenses in different courts are cognizable offenses. And non-cognizable, of course, are ones where the police officer can arrest without a warrant. Likewise, bailable offenses, where the police on their own can bail you out or bail the accused out. And non-bailable are the ones where for bail, the accused is required to approach a court of law for bail. Then, on the commission of an offense, there is an FIR, 154 CRPC. Please excuse me, the PNSS, and Bharatiya Sakshi Adhiniyam, even I am to study just like all of you. So there is an FIR 154. In that FIR, the investigation procedure. Once there is an FIR, then the investigator, on the basis of the offences committed, arrests the person. And if a person is arrested, you should know that the person arrested has to be informed of the grounds of arrest. In case he is not informed of the grounds of arrest, merely on that ground, he becomes entitled to bail. And if in case he is arrested, within 24 hours, the trial court lawyer ought to know this. Within 24 hours of his arrest, he has to be produced before the nearest judicial magistrate. Within 24 hours. And then the judicial magistrate can remand him to police custody for a maximum of 14 days. Maximum of 14 days. And thereafter, if need be, to judicial custody for a total period of judicial and police custody 60 or 90 days. Here again, in serious offences 90 days and in lesser heinous offences for a period of 60 days. In case the investigation is not completed within that arrest period of 60 days and 90 days, then there is default bail or automatic bail. Apart from this, there is regular bail under 439 and anticipatory bail, before arrest bail, pre-arrest bail under 430A. And after the investigation is completed, a challan is presented to the court of the judicial magistrate or to the court of sessions. And on the challan being presented, the court applies its mind to the challan, and on application of mind, if it feels that yes, an offense under the sections mentioned is made out, the court would issue a summoning order to the accused to be summoned to the court. These are the basics which you all ought to know. A trial court lawyer ought to know the basics. At times you may succeed only on the count that there has been a mistake on the basics. that a person had not been apprised of the grounds of his arrest, that a challan has not been presented within 60 days or 90 days, that the person had not been produced before a judicial magistrate after arrest within 24 hours of that arrest. So these are the basics which you know, which you should know. And after the summoning order, when the accused appears before the court, he is required to furnish surety and bail bonds afresh, and is entitled legally to a copy of the challan. On receipt of copy of challan, the accused is charged with the offence. At the state of charge, the accused has first right to be heard through his counsel, trial court lawyer. He may make submissions that the case under the sections he is being charged of is not made out. And in case the essential ingredients of the offence the accused is charged of are missing, then the accused becomes entitled to be discharged. Discharge technically is acquittal at the stage of charge. And in case a charge is made out, then the accused is charged of the offences which are made out against him. And remember, it is not necessary that the sections which are entailed in the FIR are to be the ones for which the accused is ultimately charged. It is the discretion of the trial court either to add a section or to delete any section as mentioned in the FIR. Thereafter, once the charge is framed, then it is the prosecution evidence which is brought forth. The witnesses who are to speak, who are to prove the case against the accused, they are examined. And in criminal law, there is a presumption of innocence. Every person presumed to be innocent until proved otherwise. This is the presumption of innocence. Even in cases where there is reverse burden, guilt is presumed, this presumption of innocence stands. So, the prosecution examines its witnesses as government pleaders who prosecute in a criminal case. They present their witnesses in examination in chief, and the defense lawyers, the trial court advocates, what they are called, they have a right to cross-examine. Only two things which I would like to say as far as cross-examination is concerned. Master your facts. Master the facts of the case. If it is a case of rash and negligent driving, you should know that the vehicle was coming from Shimla to Gandal. If you proceed on the basis that the vehicle is going from Gandal to Shimla, then you have spoiled your case. So master your facts and look the witness into the eye. And the moment he bats an eyelid, when you question him, the witness is lying. If he doesn't see you in the face, then he's not confident of what he's saying. Look him in the eye, and that you can only do if you are aware of the entire facts. And the moment he commits a mistake, he'll bat an eyelid or he'll look in the other direction. Basic principle of cross-examination, that the witness should be able to look you in the eye If he is speaking the truth, he will. And if he is a smart investigator, he'll look the other side, not let you look into his eyes. Then after the examination in chief, cross-examination part is over, then there is 313, 313 CRPC, where the statement of the accused is recorded. The entire evidence that is adduced against him is put to him. And he is to answer whether that supposedly proved case against him is right or wrong, whether it is correct or incorrect. So a trial court lawyer at the stage of 313 also, after examining the entire witnesses examined, be able to make out that the offense against him has not been proved. And even at that stage, at the stage of 313, he may be in a position to get an acquittal for his client. After the 313 comes the stage of defense evidence. Choose to lead defense only if you are very confident of what you want, from the witness. He would state that. He would not get nervous. He would be confident enough to state what is factually incorrect. To state what is factually correct. He should be a witness who doesn't fumble. He should not be one to whom the prosecutor puts a case and he says yes to everything. After the defense evidence is concluded, then the arguments are heard. For the arguments, once again, marshal your facts. Read the statements of witnesses. See where the discrepancies are. Read judgments on similar facts. Know the essential ingredients of the alleged offense. If you marshal your facts, if you know the ingredients of the offense, if you know the definition of the offense, if you know which witness has said, and if you apprise yourself of the latest legal position, then there are more than 50% chances that you would be in a position to obtain acquittal for your client. Now, this is the procedural part. Now, as far as practice is concerned, there are 11 steps which are mandatory, which are necessary for a trial court lawyer. It may be a repetition of what I have earlier said. The role of a trial court lawyer in criminal cases, seriously speaking, starts with the obtaining of the challan. After your client presents himself in the court, pursuant to the summoning by the court, he is supplied with a copy of challan. Read that challan again and again, again and again, again and again. You should read that challan at least 10 times. Marshal your facts from that challan. Statements recorded under 161, 162, 140, 164. The statements recorded by the investigator. Read them. Marshal your facts. And you should be aware of the facts of your case like the palm of your hand. No one and nothing should beat you as far as the knowledge of the factual matrix of the case is concerned. You should know your facts like anything. For that, you would be required to read the challan again and again. Then see the statutes involved. What are the acts involved? See those statutes. See the mandatory requirements as required in those statutes. Then see the sections alleged. Read the definitions of those sections. It will entail a lot of hard work. But then success doesn't come easy. So go through the statutes, go through the mandatory requirements of those statutes, go through the sections alleged, and then note down the essential ingredients. Compare the knowledge which you have acquired after reading the statute, after reading the offences or the sections and the mandatory requirements. See whether those mandatory requirements have been fulfilled in the challan. Prepare notes. At your age, you would remember everything. But 10 years, 20 years hence, you would not remember everything by heart. With the increase in your work, facts would get mixed up. So always prepare notes and keep those notes in the file. Or have a small register where you maintain all those notes, where you jot down the essential requirements or the mandatory requirements, where you put it in black and white that this was the necessary requirement which has not been complied with in the challan, so that you remember it every time you open your case file. And then read judgments. Read judgments of similar offences. Articulate a defense. Think for yourself. Try and create a defense. In case you feel that no defense is made out, read judgments of similar facts. See what the defense taken by the lawyer there was. Maybe you get an insight. Borrow that defense from there. And then articulate on that defense. Maybe you are able to make out the defense in your case. And then, as I had told you, prepare notes of that defense. This is most important. Most important. And the major acts, IPC, CRPC, Indian Evidence Act, they should be your Gita, Bible, Quran. As and when you have time, read the provisions. And every time you come across a case, every time you draft anything, every time you discuss anything, every time you think about an offense, open that book. See the section. Even if you are required to do it 100 times, open that book, read that section 100 times. And every time you read it, you reread it, a new defense will come to you. Every time a new interpretation would come to you. So read IPC, read the CRPC, and read the Indian Evidence Act again and again, again and again, again and again. You should know your facts. Law you would come to know with the passage of time. The legal position may change, but the facts of a case won't change. And let me tell you, the trial courts majorly are courts of fact, not courts of law. So if you know your facts, you may be able to get your accused acquitted without relying upon the requirement of case law. On the basics itself, you may be in a position to get your accused acquitted. And last but not the least is that winning is not important. It's not this that you would be a good lawyer only in case you win a case. It's not this. Maybe in the initial years of practice, you would be very happy saying that you got 3-4 cases or 5-6 cases or 8-10 cases and you won all of them. But with the passage of time, you would realize that it is not winning on the basis of which you get recognition, fame, name. It is on the basis of your hard work. It is on the basis of how you present the case. It is on the basis of articulation of defense, which may or may not find favor with the judge. It is on the basis of the hard work that you try to create a defense, which may or may not find favor. It is on the basis of this that you would earn a position of a good, famous, and sought after trial court lawyer. I would end with what the famous senior advocate Kapil Sibalji said when he had completed his submissions before the Honorable Supreme Court in the case where Section 370 was abrogated. The submission stood completed and the judgment was to be announced. Just before the judgment, what learned senior advocate Kapil Sibalji said, always remember that. I read, some battles are fought to be lost. Just before the judgment. Some battles are fought to be lost, for history must record the uncomfortable facts for generations to know. The right and wrong of institutional actions will be debated for years to come. History alone is the final arbiter of the moral compass of historic decisions. So, remember, it's not winning or losing. Some battles, they are fought to be lost. But it is history which decides as to who was the ultimate and final victor. With this, I conclude. And once again, a word of thanks to the Honorable Vice Chancellor, respected Chairman, sir, our respected teachers, and my dear young upcoming lawyers. I hope a day would soon come when I would be appearing before all of you, or at least some of you, and making submissions in times to come. I wish the very best to all of you. May you all work hard, and may you all of you be very successful. Good luck. Thank you. Jai Hind. Jai Hind.
Thank you, sir. for the warm and insightful words. Sir has basically completed or told us the complete process of a criminal trial. And for that, with practical application, with practical difficulties and practical knowledge. So we must commemorate Sir's lecture, and this lecture will obviously be there on the YouTube as well for you to remind yourself with that. Thank you, sir. I now invite our Honorable Vice Chancellor to present the Presidential Address. Thank you.
Thank you, Dr. Bharat. Good evening to one and all. Respected chief guests for this inaugural session of first HPNLU trial advocacy competition, and first also among all the legal schools, law schools in the country. I'm very, very happy to have you, sir, as the chief guest for this program. Shri Yash Sharma ji, Shri Kush Sharma ji, and Madam Shri Verma are the same guests who have joined this program, inaugural program. The colleagues from the HPNLU teaching faculty members, and my dear students. This particular program, trial advocacy competition, Professor Gajesh Shukla brought this before me. It was his dream project, which he wanted to execute. And then I said that why only this trial advocacy competition? You have to have a directorship of the entire clinical legal center. Because at that time I was just delivering one lecture in one of the university that we have to come out from the lecture halls to the legal clinic fields. And this is the purpose that I have started this particular center where there are four centers. One is this trial advocacy center. Another one is working as a moot court committee, which is already existing. Third one is the ADR, that is the Alternative Dispute Resolution. And the fourth one is again the new to this university, that is the Family Dispute Conciliation Center. So again, this is giving you much practical knowledge about the thing. What Dr. Gajesh Shukla has thought for and has projected that this is going to be a 10-month program starting from July to April 2026. Peeyush Verma ji has given that entire 10 months program in his lecture starting from the commission of an offense till the final judgment. So this is something like said, Gagar mein sagar bhar dena. I'm very, very thankful, Peeyush Verma ji, to you for giving this first-hand knowledge to the students so that what they have to do, how they have to do, what they have to work, and how it has to be implemented. Starting from the passion for this particular discipline, you have all chosen law discipline, and now you have to marry with the books. You have no other choice. If you want to be an advocate, a lawyer, prosecutor, judge, or even an academician, you have to have the books always with you. You have to read as much as you can because this will open your mind. This will give you the things which are there on which you can defend, you can prosecute as the case may be. It depends on what you choose. So many things have been already discussed with the chief guest, but there are few tips for you if you consider, and these tips are also, I could say, is the gist what Peeyush Verma ji has spoken, that know your case fully and know your case file inside and out equally. This is very important. What are the facts? What is the law? What are the documents? This all you have to have in your mind and head before appearing a court. Then prepare your witness well. This is another tip. Because as rightly told that your witness should not fumble. if you are confident that this witness will be one of the aspect for giving you that victory, then you have to work hard on your witness also as to what your witness is going to speak before the court. Cross-examine with a purpose. Every question must have a strategy. You cannot ask only for the purpose of asking. It must have the strategy because the judges are looking. It's not only you that you are asking because you have given the opportunity to cross-examine or examination in chief or whatever at any stage. But you are examining the person, the witness, for the purpose of getting benefit for your case. This is important. So you have to have a purpose for cross-examining the witnesses. Listen carefully in the court. It's not that your turn is over, now the opposition party or the other person or the other advocate is arguing. So you have to pay more and more ears to the opposition advocate rather than to your own self. Because you will get many new things, and out of which at that time your dynamics, your dynamism, that is important. Because you may not have prepared on that particular point. That may come as a surprise to you. But if you are giving full ears to the opposition, that again is going to add in your arguments skill. So listen carefully to the court and opportunities that may come from any side, from the other side also. Then keep questions sharp and very, very short also. So I'm also from the same prodigy like IPC, CRPC, and Indian Evidence Act, not of BNS, BNSS, and BSA. So 141, I was reminding Evidence Act, leading question type things. So that is not to be there because it is mentioned in the Evidence Act itself. But otherwise, if you are asking, your question should be very, very short and sharp. This should not be leading to any answers. Then be respectful to the judges as well as to the opposite counsel also. Because dignity in the court builds your credibility. If the opposition advocate is saying something and you are not liking, then at that time you have to have that passion. Your preparation is like that, that you can present yourself in such a dignified way so that others may also consider yourself and your credibility will remain intact. So be respectful for the judges and the opposite counsels. Then argue law with logic, not volume. Whatever you want to say, whatever you want to argue, your arguments must be based on the legal points, and you must speak or you must argue your points on logic. It is not required that you have to tell something like a story. It's a court of fact. It is clear that trial court is a court of fact, and you are an artist, rightly told. You are a storyteller there, but at the same time, you have to be very, very logical. Your arguments must be very logical. It should not speak volumes, but it should speak law. Your arguments must be based on legal points. Then think on your own feet. Trials are dynamic, as I just told you. Adapt quickly. In moot courts, in ADR, you also do all these practices, what the opposite lawyer is saying. Then you grasp that thing, and then your researcher gives you the points to speak upon. So you prepare yourself in such a way that whatever surprise is coming to you, you have the answer to that, and for that again, you have to read, and read. 10 times or 20 times, it depends on the memory as what is there and how you can sustain all these things. Then observe seniors in trials. Real trial courts will take you to the court of law also in the visit. So it's not a picnic for you. It is something that you have to observe the lawyers, what they are doing, how they are arguing. And now in this era, in digital era, you are so lucky that you can have all these online streaming right from Supreme Court and High Courts. I do not know whether any district court or subordinate court has come in this online system, but otherwise, e-courts project is there of the government of India, but otherwise, online streaming, you can have those ideas. What Verma has just told you about what Kapil Sibal said, that you can always have through the online streaming of the Supreme Court. Recordings are available. If you just go to the website of the Supreme Court, you can have the recordings of any of the cases, very important judgments which have been given by the Supreme Court. All the recordings are available. How the advocates are arguing in the Supreme Court, how the advocates are arguing in the High Courts also. Many of the High Courts, they are also having the online streaming of their arguments of the judges, of the advocates. So this is going to be one of the very, very important pointers for you to be an advocate, to be a lawyer, to be a prosecutor, to be a judge also. So whatever you have thought before joining this institution, may you achieve all those things. And at the same time, because you have registered for this trial advocacy, I wish you all good luck, though ultimately 4 teams would be there. But in this 10 months period, you are going to learn many, many things which are very important is at this time, because we did our LLB 3 years at that time. We have never seen the court of law. It is only 3 years course, and then we got the degree, and then we went to the court of law, particularly this district court. How to file this adjournment application, how to even start with the filing of your uh, signature on many of the documents. We were not knowing. So it is all learning by doing at that time, and that has taken much more period. So you are all lucky enough to get all these things in this institution along with your studies degree, and get the most benefit and opportunity which has been made available to you. With this all words, I congratulate Dr. Garjesh and his center for organizing this wonderful program. Thank you very much. Thank you once again.
Thank you, ma'am, for your visionary address. Your emphasis on holistic development and practical exposure now lights the path for all of us. As we draw to a close, it is my honor to deliver the vote of thanks on behalf of the organizing committee to our chief guest, Shri Peeyush Verma ji, for honoring us with your presence and insightful address. To Professor Dr. Preeti Saxena, our Vice Chancellor, for your inspiring leadership. To Professor Dr. Gijesh Shukla for stewarding the design and execution of this competition. To the directors of various cells under the Clinical Legal Education Center, Professor Dr. Alok Kumar, Professor Dr. Ambika, Dr. Ruchi Gupta, and to Dr. Arun Clear, the member of the Trial Advocacy Cell, to faculty members, coordinators, and especially students whose active participation animates every endeavor. A special thanks to the technical team and supporting personnel. With these words of gratitude, we inaugurate a new chapter in our legal journey. Before we conclude, may I request everyone to please rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल वंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Precious participation. Participants, please remain seated till the dignitaries leave the hall. Yes, Dr. Arun, please